All right. Importantly, what are we going to talk about today? And a lot of you tuned in because you probably read the subject line and you understand this is about the basics of estate planning and how to think about when and how you might go about establishing your own plan. So if you're a law student about to pass your bar exam, this is probably not going to be the content that will help you prepare for your exam. But if you thought that estate planning is something you should be doing and you keep postponing because you don't even know where to start and what goes into it, I think this session is going to be tremendous. And the session was conceived and put together by our very own board member, Scott McClatchey, who is a fellow financial advisor, just like me, up in North County. I'm down in San Diego. And he came up with this idea of saying, look, I talked to Greg in the past and we have valuable content. I know I get a lot of questions from people who are maybe should be doing something and they don't know where to start. How about we put together a session that walks people through these basics? And so that's the goal today. And with that, I will say again, welcome everybody and turn it over to you, Scott and Greg. Thank you both in advance for delivering a very useful session.
You're certainly welcome. Thank you for including us.
Yeah, so today, as Olivia said, we're going to talk about estate planning. Now, as a financial planner, financial advisor, one of the things I'm always, I won't say shocked, but surprised at is how few of my clients, when I first get to know them, actually have a full-blown estate plan. Some of them might have a will, some of them might have a trust, some of them might have some powers of attorney. Those are all estate planning documents, as you're going to learn in a few minutes. But it always surprises me how few actually have gone through the planning process to get an estate plan. So today, let me jump right in. Today we're going to have Greg Post as our guest speaker. Greg and I have worked together for several years. He's up here in North County, San Diego also. And Greg has his JD from UCLA School of Law. All right. And since then, he's held a lot of different positions with corporations before founding his own business, which he's doing now. Originally, Greg was Director of Planned Giving Development for USC, boo, and then Real Estate Operations and Development Legal Counsel for Dalen, Inc., Director of Planned Giving for the California Institute of Technology, otherwise known as Caltech, and Legal Counsel for Leasing Operations and Development for the Hahn Corporation. Greg opened his own private practice, more recently, the last, I don't know, Greg, has it been 10 years, 15 years?
No, it's been about 25 years. 25
years, so you're way ahead of me. And he focuses on estate planning, charitable planned giving, as well as real estate transactional law, contract law, and general business. Couple of awards. Greg was awarded the Martindale-Hubbell National Attorney Directory, highest rating AV preeminent. So that's kind of a mouthful, but that's a pretty prestigious thing, I'm told, in the lawyering community. So congratulations, Greg, on that. And he was also a San Diego top attorney from 2014 all the way through 2016. Greg's also served on the Miracosta College Board of Trustees for 10 years and was elected president 3 years. He's CEO of Yankee Ingenuity and also is founder and president of his own Amanda Post Foundation. Amanda was Greg's daughter that he has a foundation in honor of, or a charitable foundation in honor of. So with that, I'm going to launch our first poll. So we have a poll that's I'm going to ask the participants to go ahead and quickly weigh in on. It should be coming at you right now. So this is just to kind of get us level set, so we kind of know who's in the audience and what documents you might have been exposed to before or already have in place. And while I let you guys all weigh in, I'm going to just turn it over to Greg by saying this. So Greg, to get you going here, what's important about estate planning anyway? Why do people need estate plans?
Well, Scott, I'm going to answer that question a bit differently than you might expect. I'm going to ask everyone in the audience, wherever you are, unless you're driving, to close your eyes. Now you're in in a room somewhere, I'm sure, in an office or your home, so don't be bashful. Just close your eyes and I want you to ask yourself these questions. If you have your eyes closed, I'd like you to ask yourself, what if I died right this second? Not an hour from now, not tomorrow, not a week, not a month from now, right this second. What would happen to those you care about the most? Would they have any assets or any income to live on? Would they know what to do if you died? Would they even know where to find your assets or how to get to them if they knew where they were? How would they pay their ongoing bills, their credit card bills, their rent, their car payments, their mortgage? Keep your eyes closed and let's take this a little further. What if you died while on vacation in a foreign country? What if you died on your way to work? What if you are a single parent and died leaving minor children? What if you died leaving only a spouse who was suffering from Alzheimer's, or only a child who had special needs? I'm asking you to close your eyes and picture these real life situations, because in fact, these situations and many others are going on every minute of every day all across the United States. In a split second, your entire world can be turned upside down, as well as all those that you love, their worlds can be turned upside down. And we know that you can't control future events, but what you can do is anticipate and prepare and protect your loved ones in the event of your death by putting your estate plan in place. So that's what estate planning is all about.
All right, terrific. So I'm going to jump right in. That's a lot of questions, a lot of things to think about, but obviously a lot of us probably can imagine ourselves in one of those scenarios. So that makes this pretty important stuff. So I'm just going to end the polling and share the results so everybody can kind of see how they voted. So as you can see there, you've got about 64% of us have a living trust, and about half the audience listening in today has a will and or a healthcare directive or living will. And about a third of us have a power of attorney for healthcare. Not so many have a power of attorney for finance or property. It's called different things in different states, I think, as Greg's going to explain. And then there's what Greg's going to talk about later on is a to-do letter, which is kind of a, you know, something that's really important also. So I'll let that kind of lie for now. So let me just let me move on. Let's see. Let me get that off the screen. So is that off the screen? There we go. So let me move on to the next slide for you, Greg, and you can get rolling with what is estate planning. Hang on just a second. My screen doesn't want to go.
So can you remove the poll or?
Oh, is it still showing?
Yeah.
Oh, my apologies. It's not showing on mine.
No, I think it's gone.
Okay, it's showing on my screen, so there we go. So this slide asks the question, what is estate planning? Estate planning is simply what I said. It's the anticipating, arranging, and preparing the necessary documentation during your lifetime for the ultimate management and disposal of your assets and your estate during your life and after your death. When you stop and think about it, there's really only 3 places that your estate will go upon your death. It may go to the government, or it may go to your heirs and beneficiaries, or it may go to charity, or it may go to any combination of those 3, but it is going to end up in one or more of those 3 places. If you don't have an estate plan. The government, I can assure you, will have one for you. If you have a little pad of paper at your disposal, take a pen and jot down what you would guess would be the percentage of the adult population in California that don't even have any estate plan whatsoever. There are about 40 million people in the state of California, and let's just assume for discussion's sake that 30 million of them are adults. That's 30 million adults. What percentage of those adults, when they pass away, do you think will not have any form of estate plan whatsoever? So if you've jotted that number down, I'm going to ask you if you guessed 20%. If you guessed 20%, you are incorrect. Did you guess 35%? If you guessed 35%, you're incorrect. Did you guess 50%? If you guessed 50%, you're incorrect. Current statistics show that over 60% of the adult population in the state of California have absolutely no estate plan whatsoever. Now you have to ask yourself what question is, why is that? 60% of the adult population don't even have any estate plan whatsoever. The biggest reason for that is procrastination. I've heard over the years many reasons why people have procrastinated. Some people are fearful of death. They don't want to face their own mortality. Some people have said that it just seems too complicated, and because it's too complicated in their minds, they don't want to deal with it. Some people have said that the subject is too morbid to even talk about. Some people say that they're just too busy and they're going to get to it sometime, but they're just too busy right now. Some people have said to me that they haven't done it for years because they are too young, or they have too few assets to even make it worthwhile in their mind. I've had single individuals tell me that they didn't do an estate plan because they're single and they have no heirs. And I've actually had some people, very few, but some people have said that they've never done their estate plan because they're going to be dead anyway, and who cares? If you die without any estate plan whatsoever, you die intestate. So what is...
So Greg, I'm going to interrupt you real quick, and I apologize for that, but that's our next slide. But before we talk about that, when you say 60% in California don't have an estate plan, you mean they don't even have a simple thing like a will?
Correct. They have nothing. They have no plan whatsoever.
I think even in some of the answers we got to the poll, a couple of folks said we should have had the option none of the above because they didn't have in place any piece of the estate plan. And I think maybe on the positive side is the reason why a lot of these folks are here. So maybe they are convinced they should be doing something. So let's help them figure out how to get about doing that, because they already kind of want to go in that direction.
Yeah, and I apologize for that. When we structured the question, we should have had that answer. But what I didn't say is about 38% responded to the question. So that probably means the other, let's call it 60%, didn't actually have any of those documents.
Which would be right in line with
Yeah.
the current statistics in the state of California. Basically, what California government says is that if you don't care enough about your estate to do anything, to plan anything, then the state will do it for you. And they do it through the laws of intestate succession. And they do it for a person who dies without a will, without a trust. They have nothing. So their estate will be distributed according to the laws of intestate succession. So you can
In a minute,
appreciate
though,
the
that
fact.
you've had people that don't will tell you that they think they're too young. At what age do you think somebody should do a basic will?
In my view, I think any individual who is 18 years or older should have a simple will at the very minimum. If they acquire non-real estate assets over $150,000 in value, or at any age, if they acquire ownership of real estate, then I think they should consider creating a living trust. So if they should have a will, then the question is, what is a will? A will, or last testament, as some people call it, is a legal document that expresses the person's wishes as to how their property is to be distributed after their death, and as to which person is to manage the property until its final distribution. When you create a will, it's going to be an instrument that's been prepared for your signature, and it will be witnessed, your signature will be witnessed by 2 witnesses minimum, who are not related to you by blood or marriage and cannot be beneficiaries of your estate. By creating the will, however, you have made the decision that you, not the state of California, is going to decide how your estate is divided. So let's look at what are the pros and cons of a will. As you can see, the advantages of a will are multiple. It's relatively low cost to have an attorney prepare a will for you, setting out your distribution provisions and who you want to be the executor of your estate. It's simplicity at its finest during your lifetime, because once the will has been prepared, signed, and witnessed, it's going to not be activated until such time as you pass away. The results are guaranteed because you know that that will is going to go into the probate department of the Superior Court, and a probate judge is going to monitor or make sure that the guardian, not the guardian, the executor is carrying out your wishes as you set out in your will. Another very important aspect of a will is if you have minor children, the will is where you're going to designate who you want to name as guardians of their person and estate. This raises a number of questions that deserve serious consideration, and here are just a few of them. Let's suppose you die and you have 4 children. One question might be that you need to decide upon: do you want all 4 children to go to the same guardian? Or are you willing to split the children between 2 different guardians because perhaps one guardian couldn't handle all 4 children? Another issue that you need to consider is, are you willing to allow the children to move to another state if the guardian lives in another state? Another big issue that comes up in this day and age is if you named a husband and wife as the guardians of your children, and at the time you pass away, they have either divorced or one of the spouses has died, you need to consider whether or not you are willing to allow the surviving spouse to be the guardian, or if in the case of a divorce, which spouse you would prefer to have be the guardian, or would you prefer to select another alternative guardian in that situation? These are all issues that are extremely important because you're dealing with the safety and the raising of your minor children. The disadvantages of a will are also multiple. The biggest disadvantage is that your will is going to go through probate. There's going to be large settlement costs. It's going to be a lengthy time period before the estate is settled, and your will becomes a public document upon your death. So we see here that whether you die intestate, that means without a will, no estate plan whatsoever, or you die with only a will, in either instance, your estate is going to go through the probate process. It's interesting that if 60% of the adult population do not even have any estate plan whatsoever, and 25% or so have only a will, that means that 85% of the adult population will see their estates going through probate upon their death. So what is probate? Probate is simply those court proceedings that conclude all legal and financial matters of the deceased. There are a number of very large negatives by going through probate. One is that it's going to take an inordinate amount of time before the estate is distributed and the court order for distribution is given by the judge. Why is that? Because remember, 60% of the adult population have their estates going through probate under the laws of intestate succession, and about 25% of people have their estates going through the probate process because they only had a will. Another big problem and negative about probate is that when you pass away, your will becomes a public document. And there are a whole, I call them trolls, for lack of a better word, that feed on the information that they can acquire from public documents. And a will has a lot of meaty information that these trolls can use for nefarious purposes. But the biggest negative in my mind is the very high cost of probate in the form of statutory, non-negotiable probate fees. They were set in statute many years ago by the state legislature at that time, probably made up mostly of attorneys. And you can take as a rough rule of thumb, now this is a very rough rule of thumb, but it's fairly accurate, that probate fees will be about 5% of the gross estate, not the net estate, the gross estate. And that fee will go to the executor of your will to probate the estate, or if your estate's going through under the laws of intestate succession, it will go to a stranger in the form of a public administrator. In either case, the executor or the public administrator will most likely hire an attorney to handle the complex procedures of the probate process. Interestingly, the statute also provides the same statutory fee, roughly 5% of the gross estate, for the attorney. So if the executor and the attorney are both getting a 5% of the gross estate fee, here's what can happen. This is an exaggerated example, but I want to show you to see how impactful this can be. Let's suppose that you had $1 million of assets and you passed away, but you had also $900,000 of debt. The estate would be probated. The executor and the attorney would take the probate through to conclusion, and they would pay during that probate process all the $900,000 of liability, leaving $100,000 left at the time that the estate is ready for distribution. The very first payment doesn't go to the beneficiaries. It goes to pay the probate fees to the attorney and to the executor. So in this exaggerated example, $900,000 was paid out to pay the debts, $100,000 was paid to the executor and the attorney, and zero was paid to the heirs. So the real question is there any instrument out there that would allow you to distribute your estate to your heirs without having to go through probate? And the answer is simply, yes, there is. It's the living trust.
So can I jump in right there, Greg, and say, you've given us a lot of reasons to try to avoid probate, and you're about to talk to the one primary way to do that. Before we do that, let me launch a poll. This will be poll 2, and let people vote on this. And this is basically asking people, would they be comfortable, if they're named as an executor or an administrator of somebody's will? Would they know what to do? So we'll give that a minute to run. And while we're doing that, you mentioned also, Greg, a minute ago that probate takes a long time. How long have you seen these things run? Are they,
Well, that's a good question.
How long do they
For
run?
an uncontested probate, I'm glad you brought that up because I did not mention how long it takes on average. For an uncontested probate, and by that I mean people are not fighting over the assets, they're not challenging your will, they're not challenging the distribution, it's uncontested. On average, it takes between 12 and 18 months to go through the probate process. And during that time, your heirs will not receive any of the assets. Only after the court adjudicates final distribution will the assets be distributed. I'm glad you brought that question up because if it's a contested probate, those probates can last for years. And during that time, the heirs don't have access to any of the assets. And why is that it takes so long? The reason, again, is that 60% of the adult population have their estates go through probate under the laws of intestate succession. 25% of the adult population have their estates going through probate because they have just a will. That means that the courts are clogged to the gills with estates, hundreds of thousands of people in this state. We don't really realize that in one sense, but hundreds of thousands of people die in this state, all over the state, every day. And with those percentages, you can see that the 85% of those estates are going into the probate process. That's why it takes so long for estates to be probated. So then you have to ask your question, I'll have to remove that slide from my.
Yeah, I was just going to share the results real quick, just so everybody can see them. But it looks like the most people in the audience are feel somewhat comfortable if they had to be an administrator, an executor for a will. They could probably figure it out. A few of you sounded like you were pretty comfortable, and a few weren't comfortable at all. But which is maybe why you're here. So let me stop sharing that. So hopefully that'll disappear off the screen. And then Greg, I'm gonna
have to question whether do you want to create a will or do you want to create a living trust? That's your dilemma. So we are now going to look at what is a living trust. I'm going to hit that, yeah. A revocable living trust is a trust document that's created for the individual, by the individual, that can be changed as many times as you want during the creator's lifetime. It's amendable, it's revocable. There are many types of trusts out there. There are irrevocable trusts, which means you can't change them once you've signed them. There are revocable trusts like the living trust. You can amend them, you can change them at any time. There are trust designs for special purposes, like a charitable remainder trust that's designed to provide income streams and tax deductions for donors to charitable organizations. There are special needs trusts for children or adults that have special needs. There's life insurance trusts designed to take the death benefit out of the taxable estate for estate tax purposes. But what we're looking at here is the living trust and its primary purpose. It's designed primarily to avoid probate, to enable you to pass your assets on to your beneficiaries without having to go through the onerous probate process. One thing that's important to think about is that your living trust becomes the foundation block for your estate plan. It avoids probate, so it's a much shorter time for distribution. You'll be able to, your trustee, your successor trustee that you name will be able to distribute the estate usually in 4 to 5 months rather than 18 months as occurs with probate. It's private. It never goes into the court system. It's never becomes a public document. There are absolutely no probate fees. And in some cases, particularly with large estates, the living trust can help to minimize the state taxes to some extent with special types of living trusts. I kind of like to do a little segue here because sometimes people confuse probate fees with estate taxes. They use them interchangeably, thinking that they're the same thing, and they're not. Probate fees are fees set by statute to pay to the executor and or the attorney for probating the estate. They're non-negotiable, they're set in statute. And they are based on the gross estate, as we talked about. Estate taxes, however, are taxes. That's exactly what they are. They are taxes on the estate. And it's imposed upon the estate upon your death. So let's take a brief detour, if we may, and talk about the estate and gift tax exemptions and the estate and gift tax laws. Currently in 2020, each of us in this country, each adult, has a $11,580,000 exemption from estate taxes. What does that mean? It means that if you have an estate under $11,580,000, you will pay no estate taxes whatsoever. If you have an estate over that exemption, then there's a 40% tax on every dollar over that exemption. So for example, if I had a $12 million estate, I don't, but if I did, I'd love to, but if I did, I would have no taxes on the first $11,580,000, but I would have to pay a 40% tax on every dollar of the $420,000 overage. Under the Unified Federal Estate and Gift Tax exemption, there is, in addition to that, an annual gift tax exclusion. In 2020, each of us could give $15,000, up to $15,000 to as many people as you wanted to and not pay 1 cent in gift tax. I had a client, she's now deceased, but over many years, she gave out 35 individual gifts every year up to the maximum exemption for that year. So for many years, the exemption was $10,000 per person. So she would give out $350,000 every year. And it was wonderful for her because she was able to make these very generous gifts to people. And despite giving $350,000 away every year, her estate continued to grow. So that was wonderful. But let's suppose that she was living today and she wanted to make the same 35-person gift at $15,000. She would be able to give away $525,000 to 35 people and not spend a dime in gift taxes. Well, let's take it a little further. Supposing that she wanted to give away $100,000 to 35 people. Could she do that? Sure, she could. What would happen? She would be giving away $3.5 million to 35 people. First thing that would happen is that annual exclusion of $525,000 would be deducted from the $3.5 million gift. That would leave $2,975,000 subject to gift taxes. She would elect the option to apply the unified estate and gift tax exemption of $11,580,000 toward that $2,975,000 overage and not pay any gift taxes whatsoever because she's using part of her lifetime exemption. If she died that same year,
Greg,
she
let
would still
me
have,
jump in real quick.
Yeah.
Help me understand and help our audience understand. They sound like two different things, but you're saying the gift tax and the estate tax are somehow unified. Why are they unified, and how does that work?
Well, that's the way the law was designed, is that you, in your estate planning and as far as taxation is concerned, you're able to use your exemption any way you want to. You can apply it all to your estate when you pass away. You could apply it all to gifting while you're alive, or you could do a combination of the two. And that's what I was trying to demonstrate. Obviously, I think I was throwing around numbers here that it got to a point that it's hard to follow. And I'm glad
that's okay. But I guess
I'm glad you popped in on that, because that.
Well, what I'm trying to get at is I think
is that it's very flexible and you can use it that way.
Okay. Yeah.
So let's get off of that subject.
Is,
I just wanted to give you a little brief understanding of the estate and gift tax laws that currently exist in this country. They can always be changed. Congress is the one that makes the determination as to what the exemptions are, what the taxes are. So it's always subject to change if Congress deems it appropriate to change it. But right now, we live with the laws that we have, and the exemption for each of us, which goes up each year by the CPI, Consumer Price Index. So next year, 2021, the exemption is going to be a little higher. But right now, we have $11,580,000 exempt from the state taxes and gift taxes. So going back to our slides, we know that the most important thing is that living trust avoids probate. That's what it's focused on. That's what it's designed to do. And that's why it's so beneficial. So let's ask ourselves now, who are the parties to a living trust? Get that slide there? Yeah, there you go. Well, the parties are the trustor. That's the creator of the living trust. That's you. You created the living trust. You're the creator, O-R. You are the trustor, O-R. Notice that all the parties except the beneficiary have the word trust in the name. Even the trust has the word trust. This is based on trust. So you as the creator create your trust, and you name someone that you want to serve as the trustee. Now, initially, most people serve as their own trustee during their lifetimes. So they create the trust, they're the creator of it, and they manage the trust, they're the trustee. And they are also, during their lifetime, the beneficiary of their trust. So in effect, you are wearing all of the hats. You created it, you manage it, and you're the beneficiary of it. You're doing everything exactly the same way as you're doing things today, except you have the word trustee behind your name. That's an easy way to picture it.
So what are the qualities somebody would look for if they're looking for a trustee? If they want to hire somebody or ask a friend to do it, or maybe even a corporation?
Okay, well, I can answer that question. If you look at the trustee's responsibilities, when you, as the creator, are the trustee of your own trust, you're going to be handling your day-to-day operations just like you have been doing before you had the trust. Again, you're only going to have the difference of having the word trustee behind your name. But when you pick the successor trustee, you have to realize that that successor trustee is going to have a number of responsibilities. When they step into the trustee position, they become fiduciaries, and they have a very high standard to meet when serving as a trustee. They have to garner the assets. That means gather up all the assets. They have to value the assets, all of them, as of the date of death of the trustor. They have to file tax returns, the 1040 for the decedent, and perhaps even a 1041 for the trust. They have to pay off all the bills. They have to do a final accounting to all of the beneficiaries, a detailed final accounting, and it has to be to the penny. They have to account for every dollar spent and every dollar taken in. And they also have to distribute the assets. They also have to listen to and take advice from the professionals that worked with the decedent when the estate was created. If they don't conduct their trustee responsibilities in a fiduciary manner, they can be held personally liable for their errors. Because there's so many responsibilities for the trustee, I always recommend that your trust contain a paragraph providing for trustee fees for the trustee. About 1% to 2% of the gross estate is usually within a reasonable realm. The trustee fees have to be reasonable. Now, who would you select? You obviously should select someone that you trust. That's most important. Everything is based on trust. You should select somebody who is level-headed. And also, if you can, select someone who has some financial sense. You should also consider selecting someone who you know would listen to the advisors that you have had around you during your lifetime, your CPA, your certified financial planner, your life insurance agent, your attorney. That's the team that a good estate plan will have around them. Now, this trustee that you select can be a family member, it could be a friend, it could be one of your advisors, or it could be, in some cases, you might want to select a corporate entity or what's called a private fiduciary that specializes in trustee administration. The cases where I recommend someone hiring a corporate fiduciary or a professional private fiduciary are situations such as estates where there's a great amount of conflict among the family members. You know that if you name one of the family members as a trustee, sure as shooting, you're going to have another member of the family file a lawsuit trying to get rid of them as the trustee. Or if they're fighting over the assets, there's going to be litigation on the horizon. It's best sometimes to defuse the situation by hiring a non-interested third party, such as a corporation or a private fiduciary. Another instance would be if the estate is extremely complex. I have a case right now where I recommended a private fiduciary because the client has multiple assets in multiple states, and there are very detailed, complex tax issues involved with that estate. Also, the last analysis, if the people that you select say, I don't want to do it, then I definitely would look at a private fiduciary.
Hey, Greg, sorry to interrupt. We got a question here, practical question, and I know you can't give legal advice on a Zoom call without even having met the folks, but as far as the typical situation with a married couple, do you see them create two separate living trusts and then make each other the surviving trustee upon their spouse's death, similar to having two separate wills, or is there another setup that should be considered?
No, that's a good question, and certainly one that comes up often. And you can, with a married couple, you can create a living trust, a single living trust that applies to both spouses. And typically in a straight living trust, the trust would typically provide that during their joint lifetimes, they would both be co-trustees of trust. And then if one of them passed away, the survivor would be the sole remaining trustee. And then upon the death of the survivor, the successor trustee would come in and distribute the estate according to their wishes. So you can have a single trust. Now, each of the spouses would have their own separate ancillary documents, which we'll be discussing in a few minutes. But that's a good question. And yes, you can create one trust with the spouses.
Before we move on, Greg, one other question did come in from the previous slide when we were talking about estate taxes and gift taxes. And the question is it the recipient of the gift that pays the taxes, or is it the donor of the gift?
No, it would be the gift tax or the estate tax would be paid by the estate or the person donating it. So if you got a gift, you're not going to get stuck with gift tax.
Right.
After all, it's a gift. You don't want to be subjected to taxation. When you create a living trust, you have to take two equally important steps. This is crucial to know. Unlike a will, when you sign your will in front of two witnesses, your entire estate is now governed by that will when you die. However, remember that will is going to go through probate. The living trust, which is going to avoid probate, has to have two steps taken. The first is to prepare and execute the trust documents and sign it in front of a notary. The second and equally important step, however, is that you must fund the trust. And what I mean by that is that you have to physically transfer your assets into the trust. You're moving the ownership from an individual basis to the trustee of the trust. What are the instruments to do that typically? For real estate, the most common way to transfer or fund the trust with the real estate is to have a quitclaim deed prepared. Basically, this is a deed that transfers it from your name as an individual to your name as trustee of the trust, and it's recorded. And when you submit it to the county recorder, they have a specific exemption from reassessment, so you don't have to worry about your property being reassessed because you changed the ownership from your name as an individual to your trust. For changing bank accounts and transferring them into the trust, or transferring brokerage accounts, for example, into the trust, every institution has very straightforward instructions on how that institution wants you to transfer the asset into the trust, and you simply follow those simple, straightforward instructions, and your asset will be funding the trust. Now, it should be important to note here that not all assets should be transferred, have ownership transferred into your living trust. That's important to know. Such things as life insurance contracts, you're not going to want to transfer the ownership of a life insurance contract or an annuity into the living trust. You're also not going to want to transfer ownership of an IRA or a Roth IRA or a 401k or a 403b or a 457 plan into the living trust. Because if you change ownership, you transfer ownership of those plans into your trust, you're going to trigger a tax. And it's not a pretty tax.
Greg?
At most, if you wanted to make sure that those assets got distributed according to your wishes, you could, after consulting your CPA, after consulting your attorney and your certified financial planner, you could consider naming the trust as a contingent beneficiary, not the primary beneficiary. Don't recommend that. But in some cases, if the primary beneficiary predeceased you, you might want to consider naming the trust as a contingent beneficiary. Note the difference. We're not talking about changing ownership of the asset. We're talking about just designating the trust as a beneficiary. Hugely important thing to note.
So Greg,
Ownership, you're going to trigger tax.
Greg, sorry, can you hear me?
Yeah.
Sorry, quick question. So for the folks who are not busy taking detailed notes of everything you're going through and who are not going to remember these to-dos and not to-dos, is the process for most folks based on them being in touch with an attorney? And I'm not trying to plant you as necessarily,
That's a good question.
So rather than think about all the nuances that they would have to discuss with an attorney, is it more important to say, look, we want to do something, we need to find some guidance and some help in discussing all these things, because frankly, it is intimidating how many nuances all these decisions have and how wrong can they go based on something very, very seemingly minor. So from the perspective of,
I see what you're saying. And I think that's a very good question. I would highly recommend that you seek out an attorney that specializes in estate planning and ask for a no cost interview. In this day and age, it would most likely be over the phone.
Okay, like a free consultation, initial
Free
consultation. Yeah.
And you want to ask them how much they charge to prepare the trust and the ancillary documents we're going to be talking about a little bit, how long it takes to get it from creation to signature to having your assets transferred into the trust, whether there's any hidden fees, such as some attorneys, unfortunately, some attorneys charge a fee to transfer each and every asset into the trust, besides the cost of preparing the trust. There's going to be notary fees. That would be paid most likely to the notary directly. Some attorneys have notaries in their office, so it's included in the cost.
So you're saying a good estate planning attorney would understand the need of somebody to ask these questions in advance,
Absolutely.
and they would be happy to entertain them and give you a good idea of, hey, this is what you will get, and this is how long it's going to take, and this is how much is likely to cost. Correct. Approximately, right? That would be a good way to think about it.
So my recommendation to everyone listening is that I think it's very important that you select a CPA, a certified financial planner, a life insurance agent, an attorney that you feel comfortable with. And the only way that you're going to feel comfortable with them is to do an interview them, knowing that it's a no-cost interview, complimentary, ask all the questions you want to ask. But what happens if once you select, let's say that you select an attorney that you feel comfortable with, when you're meeting with that attorney, if he or she is worth their salt, they're going to be asking a number of questions about what your estate is made up of. What are the assets in your estate? And when you point out that you have some life insurance policies and 401ks and IRAs, they should point out to you that those assets are not assets that you want to put in the living trust. And in fact, you will note that on all of those plans, they have designated beneficiaries. So
we actually
conversation should occur with the individual that you select to prepare your estate plan.
So here are 3 questions that we got live. Thank you everybody for submitting questions live. And don't mean to derail necessarily the flow of the presentation. The goal here is to make it helpful for everybody on the call. So
Sure.
Would you move bank assets, i.e. checking savings, into a trust? Would you put IRA accounts if they're not in the living trust, would they go through the probate process? And there was another one here, I guess related, which of these financial assets should stay out of a trust? And obviously there's a comprehensive list, but maybe you can give us some high points there.
Yeah, we'll touch on just some major issues. If your bank account is in your name and it's not a bank account that's a part of an IRA or a 401k, you would transfer that account into your trust.
Okay.
If you had a brokerage account that you like to buy and sell stocks, and that's something that you enjoy doing, and it's not a brokerage account in the IRA or the 401k, you could transfer that into your trust, following the procedures of whatever institution you're dealing with. If you have real estate, assuming again that it's not in any particular plan, that you would transfer that real estate into the trust using a quitclaim deed. Those items such as 401ks and IRAs, they have designated beneficiaries in them. And when you pass away, if the beneficiary is living, that account will go directly to the beneficiary, and it's not going to be going through the probate process. So hopefully that touched on those items.
I think that's clear. So if you have an option of checkbox or a field where you can enter a beneficiary and you put somebody there that is still live when you pass away, that person will get the assets.
Right.
And if you don't have an option and you don't put the assets into the trust, it will go to the probate. Is that a fair generalization?
Yeah, that's a pretty good generalization, but let's note a couple of things. When you're having your estate plan and you're having your living trust prepared, this conversation should go on with regard to each and every asset that you have in your portfolio. And I always recommend, even if you've talked to your financial planner recently, I recommend to you that you periodically check the beneficiary statements on every asset that you have. Here's an example of something that can happen, and it can be a disaster. 50% of the adult population in the country get divorced. It's just a fact, unfortunately. Let's say that you had an IRA or 401k and you had named the beneficiary your first spouse. get divorced, but you fail to change the beneficiary designation. You get married to a second spouse and you die. The second spouse, and this is a generalization, but if you did not change the beneficiary designation on that 401k, the first spouse named as the beneficiary would get that asset. That's not going to sit well with the second spouse. So it's important, that's just one example. It's important to have your attorney, when you're doing your estate plan, have him or her, have you provide him with, or her with the current beneficiary designations on every account, your IRAs, your 401ks, your life insurance. That's extremely important to do, and that should be a part of a good attorney's service when he or she is preparing your living trust. So let's jump back on this because we don't want to run out of time. But so the question is, how does a living trust work actually? Well, we know that when you create the trust, you're the trustee, you funded the trust, you are managing it just like you've always done with all of your assets during your lifetime. But then when you pass away, the successor trustee steps in and carries out all the fiduciary responsibilities that we talked about earlier, and then ultimately distributes the assets according to your wishes set forth in the trust to your heirs. So let's ask ourselves then, what is it that a living trust won't do? We know that it will avoid probate, that's its primary purpose, but what is it that it won't do for us? And here's a list of them. I'm not going to go through all of them, but I'll touch on a couple. A lot of people think that when you create a living trust and you put your assets into the trust, that you are somehow shielded from creditors. I've had people say that all the time. You're not shielded from creditors. You're also not shielded from litigation damages that may be awarded to a plaintiff in litigation. Why is that you're not shielded? Because it's a revocable, amendable trust. You can change the terms of the trust. You can pull assets out of the trust. You can put assets in the trust. You can amend the distribution provisions. You can select new trustees. You can do anything you want to during your lifetime. And because you have all those powers, the law says that you can't use that trust as a shield to protect yourself from litigation damages or creditors' claims. That's a very important thing to note. Besides the living trust then, is there any other way that you could avoid probate? If you didn't...
I'm going to jump to that slide for you, Greg, but I just wanted to point out, go ahead and cover, the TOD, POD stuff on this slide. But there's several questions that have come in this area, so I want to stop you after we get through with the slide and kind of go through some of those questions.
Well, I can go through now if you want the questions.
Well, go ahead and explain this first so that they.
All right. There are several alternative ways to avoid probate without using a living trust, but I call every one of these options two-edged swords, and I'll tell you why. One of the most common tools used to avoid probate is joint tenancy. Let's say that you and I acquired a piece of property together as joint tenants. If I die first, you as the surviving joint tenant takes all. The key phrase is he or she who survives takes all. So what happens with my death? You would file an affidavit of death of joint tenant. You would record it along with a certified copy of the death certificate. You would issue a new deed in your name alone, and you have just bypassed probate. Sounds good, but there's a problem. Now the joint tenancy has ended. If you then die and you haven't had a living trust prepared, your estate is going to go through probate, either because you didn't plan anything, so it goes through probate under the laws of intestate succession, or you had a will and it's still going to go through probate because a will also goes through probate. So it's a two-edged sword, because if you die and don't have a living trust, it's going to end up in probate along with all of your other assets. Take the bank account, POD, pay on death designation, or the brokerage account, transfer on death, TOD designation. Basically what you're doing is you're opening an account and you're designating a specific beneficiary to receive that account on your death. If that person survives you, great, they get the asset. But if the person that received the asset doesn't have a living trust, their account that they just received from you because you died will go through probate. And vice versa, if the person you designated as the primary beneficiary for that account dies before you do, then the account will come back into your estate on your death. And if you don't have a living trust, it will go through probate along with all of your other assets. So all of these are ways to avoid probate, but they are a two-edged sword. So now let's jump back to your other question.
So one of the questions was POD accounts for non-retirement assets should not go into the trust, correct?
POD account, no, I'm suggesting that.
You're suggesting
I'm suggesting the opposite.
Don't bother with the POD.
I'm suggesting I would not use a POD account to pay on death to a specific beneficiary unless I had a living trust in place already, because if the primary beneficiary dies, it's going to come back into my estate because there is no designation. And then because it's back in my living trust, I would be able to distribute it through my living trust, provided that I had designated the trust as a contingent beneficiary. The better way to do that would be simply to have the bank account put into your living trust in the first place. So you know that if the primary beneficiary of your trust dies, then the contingent beneficiaries that you've named in your trust are going to receive the assets. You don't have to worry about what if something happens to the primary beneficiary on a POD account. So again, I recommend that don't use these tools if you're thinking of using these tools as a simple way to avoid probate, because they are a two-edged sword and they're going to come back and bite you. Sure, Stephen.
One other question that came in a little bit earlier is about trusts in general. And they're asking if they're specific to the state laws. And if you move out of state, let's say from California to, I don't know, Arizona or Texas, you need to dissolve your existing trust and get a new one, or can you just modify it?
Good question. Every state in the union recognizes your trust. So if you have a living trust and you put your assets into the trust, you can be assured that your trust is going to be recognized, and you're going to avoid probate in whatever state you're living in. Here's something that's interesting though. If you don't create a living trust and you own real estate in, let's say, 3 states, you're going to have 3 probates going on at the same time, because they will be a probate in every state where you have real estate located. So your estate, because you're gone, but your estate could be saddled with years of probate process because you had 3 or 4 probates going on in 3 or 4 different states all at the same time. That's a huge mess to leave your heirs to deal with. So if you create a living trust and you transfer the real estate in other states into the trust, which you can do, then that trust, when you die, will govern the distribution of the asset regardless of what state it's in.
Another question that came in has to do with taxes, Greg. So they're asking if trust, and I think they're talking about a living trust here, does the trust provide a stepped up cost basis to the heirs for real estate upon death, number one? And then number two, does that happen automatically in California?
Good question. Yes, there is a step up in basis for property at death. That's why it's so important that the successor trustee has the property appraised. If it's real estate, it has to be a certified real estate appraisal, not a broker driving by and looking out the window and saying, I think I can get $2 million for that property. That's not a valuation. It has to be an IRS approved appraisal, and that is typically a licensed real estate appraiser doing the evaluation. Also, brokerage accounts, bank accounts, the fiduciary needs to get the date of death value for all of those accounts, because the IRS says that assets that have appreciated are going to have a step up in basis to the value as of the date of death. IRS also takes the position that if you don't do that, if you don't get a valuation as to the value of the asset at date of death, the IRS can deem that you don't have sufficient evidence to prove that the basis has stepped up, and it will go back to what your basis was when you acquired the property. That could be catastrophic. So it's very important that your fiduciary get valuations on all of the assets, particularly the assets that have appreciated.
And just to confirm, if we're talking about a bank account, a brokerage account, or a piece of real estate, whether it's owned by the trust or owned outright, in both cases, the stepped up cost basis will happen as long as you make it happen.
That's correct. Yeah. Okay. It's just whether or not you want your estate also to go through probate.
Understood.
The living trust is designed to avoid probate. That's its primary function.
Right. Let me jump back in now so that we can get through some of these. Then we may have a little bit of time at the end for some questions. But since we're about 15 minutes out, I want to keep us moving a little bit. So here we go.
Okay. So when I talk about creating a living trust, I'm automatically thinking about what I call the living trust package. The living trust is the primary foundation block of your good estate plan. It's the hub of your wheel. But there are a number of ancillary documents that are very important and are included whenever I do an estate plan for a client. All of these documents are included when I talk about the complete estate plan. First thing I'm going to talk about is down at the bottom, the pour over will. That's a backup will. It's a safety valve. First question I get many times is, I thought we were trying to design my living trust so that I won't go through probate. And you just told me that if you have a will, it's going to go through probate. That will hopefully will never be used. If you transfer all of your assets into the trust, then the trust alone will dictate the distribution of the estate, and it will never go into probate. But let's take an example that I like to use, and it's kind of an absurd example, but it makes the point. Let's suppose that you've just created your living trust, you've transferred all of your assets into the trust, you're really feeling good, and you decide to take a quick trip up to Julian, which is a little resort town outside of San Diego, up in the mountains. You go up there, now bear with me, this is an absurd example, but you'll see what I'm saying. You're driving around and you see this cabin that you just think, I gotta have that cabin. I've always wanted a cabin in Julian, and there it is. There's a broker sitting on the property and there's a for sale sign on it. You go in, you have your checkbook, you write a check for it, you purchase it outright. He happens to have a deed there and he prepares it and he says, it goes to you as an individual. You jump in your car, you're so excited about this new acquisition. You're driving around down back to San Diego, and all of a sudden you realize, I should have taken title in the trust, not in my name as an individual. I should have taken title in the trust. So you think, well, what I'm going to do is I'll go right down to the county recorder, I'll fill out a quitclaim deed, I'll get it notarized, and I'll transfer it into the trust. You go around a curve a little too fast and go off the cliff and you're dead. Now, you intended to put that property in the trust. You even realized that it should have been in the trust, but it wasn't in the trust. So when the successor trustee of your estate is looking through all the assets, he sees that all of the assets have been transferred into the trust except this one cabin that was recently acquired. So all the other assets that are in the trust will be distributed according to the terms of the trust very quickly and without any probate fees. But that one asset, that cabin, is going to have to go the long way around. It's going to be going into probate vis-a-vis the will. And after 18 months of probate, the judge will finally look at the will and say, how did he or she want to have this one asset distributed? Oh, I see in the will it says distributed in accordance with the terms of the trust. In other words, the asset went through probate and now it's being poured back into the trust for distribution. That's why it's called a pour over will. Very important. If you've transferred all your assets into your trust like a good boy or girl, you're never going to ever use that document, but it's a very important asset to have as a safety valve. The other items are powers of attorney, and there's a power of attorney for financial matters. You designate someone as an agent for you, and that person can handle financial matters on your behalf. They step into your shoes, basically. You might want to go to that next slide. The other power of attorney that's very important is the durable power of attorney for healthcare. This document is important for expressing your desires with regard to when and if feeding tubes and hydration tubes should be provided. If you're unable to make healthcare decisions for yourself, your agent will be making these decisions based on your expressed wishes. Should you have life support systems applied, and when and if they should be supplied? What kind of circumstances should pain medication be provided? Do you want to donate your body organs, or do you want to donate your body to research or dissection? Do you have any life-threatening allergies that the medical community should know about? Do you want to be cremated, or do you want to be buried? Do you want to have a funeral? Do you want to have a memorial service? All of these items you express in the durable power of attorney, and it's a very important document to have. I recommend that when you go on a trip, you make a photocopy of your durable power of attorney and take it with you, because you never know when it might be needed. Other documents that are not shown in that slide are assignment of personal property. You can't title furniture and books and collections, but you can transfer them collectively by an assignment of personal property. It also will have a certification of trust document. This is a one-page sheet of paper that's notarized. It says, what's the name of the trust? What's the date of the trust? Who are the trustors? That's the creators. Who are the trustees? That's you. Who are the beneficiaries? That's you. Is it revocable? Yes, it is. Can one person sign bank checks, take money out, put money in? That's your decision. And then what's the tax ID number of the trust? Typically, it's your own Social Security number, because you have the power to revoke and amend that trust. So it's under your Social Security number. Only upon your death does the trust get assigned a new tax ID number, because you're no longer living. Now, there's one further step that I highly recommend that you take after you've created and funded your living trust. I highly recommend that you create what I call the to-do letter. Now, the to-do letter is a letter to the trustee and the survivors that provides information as to the location of your assets, the identity of professionals you have consulted, the location of your records, and a list of steps to take immediately upon your death. The attorney that you have prepare your living trust can provide you with the contents for a good to-do letter, but these are generally the things that I suggest be included. The reason that you have that letter is to provide guidance to your survivors during a very emotional period of time. I'd like to close with one last thought because we're running out of time. And that is, by far the biggest obstacle to people completing their estate plan is procrastination. Procrastination is passive. It's doing nothing. It's putting off till later what you know inside yourself you should be doing now. Procrastination breeds regret. It's knowing that there were things that you should have done, but you didn't do, and now it's too late to do it. The antidote to procrastination and regret is caring. And caring requires action. When you create your estate plan, you are taking action to provide for the people that you care about. And this benefits not only them, but it also benefits you. I've had more people than I can count tell me that after they've completed their estate plan, they feel a huge weight lifted off their shoulders. And they wonder why they haven't done this years before, but they're certainly glad that they have gotten it done. So with that, I'd like to thank all of you for participating, and I hope you all have a great evening.
Terrific. Thank you, Greg. I appreciate that. A lot of good information. There are a few more questions. Before I hit those, though, let me just point out a couple of things real quick to people that might want to drop off. We've got about 5 minutes, and I'll respect that, and we'll cut off in about 5-6 minutes. But I do have one last poll. I'm going to ask you about other topics you might want to see us do in the future. But I'm also going to point out we're going to send an email to everybody who registered, so that you'll get a link to today's webinar if you want to see it after the fact or share it with somebody else. Number one. Number two, I'll attach the slides so you can have the slides. And number three, there will be a link also to a survey, so you can tell us what you liked or didn't like about today's session. So I'd appreciate everybody if you could fill those out. We appreciate that. We try to make these things impactful and provide good information for folks. We don't always hit it exactly right, though, so tell us where we messed up, and we'll fix it in the future. So with that, I want to thank Greg, and I want to launch the poll real quick, and then we'll get to a couple more questions and leave it at that. So here we go. So while we're doing that, a few other questions, Greg. You and I can talk while they're answering the poll. Are there tax strategies to shelter estates above the uniform gift and inheritance tax level?
Oh yeah, there's some great strategies to use. One of my favorites is the charitable remainder trust and what I call the wealth replacement trust. So those are two instruments that are used quite frequently for particularly large estates, and I'd be glad to share that information with whoever is interested in another presentation if UCLA will have me do that.
And even just sometimes a bypass or an AB type trust, right? For
you can also shelters to some degree, yes, you can use.
And then the same question they ask about insurance or other structures to minimize tax exposure. So maybe ILETs they're talking about, life insurance trusts.
Right, that's what I call a wealth replacement trust. Sounds better than life.
Is moving assets into a trust a taxable event since the ownership of the asset has now changed?
I'm sorry, what was the question?
When you move your assets into the trust, the living trust, does that cause a taxable event?
No, good question. No, it doesn't. All you're doing is transferring your estate asset into your living trust document does not trigger a tax.
Okay, and then somebody else asked, what is a stepped up cost basis? If you don't mind, I'll take that one real quick.
Yeah, you take that one.
When somebody buys an asset, whether it's a stock or a piece of real estate, at $100 and then sells it 10 years later at $200, they have a $100 capital gain that they have to pay. And so that $100, the initial purchase price is the cost basis for tax purposes. And what happens when somebody dies is you get that step up, which means the cost basis gets changed so that when you eventually have to pay capital gains taxes, if you do, your cost basis is much higher because you got a stepped up basis on the death of whoever you inherited the property from. And then I'm just seeing if there's any that we missed here. I think we got most of the others. I'm going to come back to the poll here. So in polling, here come the results. So yeah, interesting results. So it sounds like we would like to hear some investment topics down at the bottom there. And then maybe a few more on the retirement or on the estate planning side as well, in philanthropic gifting. So Greg, for those of you that may have read the bio up front, I didn't mention this too much, but he's an expert not only in estate planning, but also in planned giving, philanthropic giving programs. So that's something to keep in mind. I think we are just about out of time. So Olivia, if you want to say anything else, go for it. Otherwise, we'll close it out.
Yeah, well, thank you, both of you, for providing the content and the platform. And thank you, everybody, for tuning in and for asking us the questions. Please, please, please help us with that survey. It's very quick, 3 quick questions with pre-select answers and an open-end question that you can just type your feedback for us. And with that, I will say have a good evening, everybody, and we will see you at the next UCLA Anderson San Diego chapter event.
Good night, everybody.
Thanks, everyone. Go Bruins.
Go Bruins. Bye-bye.
So I was supposed to ask Greg at the end here, if anybody's still on, who would you root for in a UCLA versus USC football or basketball game?
Well, if the two are competing, I never have to worry because I'll always be cheering for the winning side.
Yeah, full disclosure, Greg has a degree from both universities. Little unusual, but anyway. Thank you, everybody. Thank you, Greg. Great job.
Thank you all. Bye-bye.